This screencast lecture continues our introduction to the topic of nondisclosure and concealment. This second part focuses on the disclosure rules that apply to the real estate sales in Reed v. King and Stambovsky against Ackley. Recall first that Reed arises in California. The situation is reminiscent of Simpson's episode number 909, Reality Bites. The plaintiff, who's the proverbial little old lady, purchases a house where brutal murders were committed. When she later discovers this fact, she sues for rescission. The very punny opinion in Stambovsky was written by a New York trial judge who evidently had way too much time on his hands. The plaintiff, who's a big city rich guy, buys a supposedly haunted house from a possibly crazy lady in Nyack. He too wants rescission. Interestingly, both plaintiffs prevail, but for very different reasons. Let's see why, and we'll also consider the legislative reaction to cases like these. Historically, the traditional common law rule for real estate sales was caveat emptor, let the buyer beware. The seller had no duty to disclose anything. She can't conceal information, but there's no need to disclose. Let's start with how California law deviates from the traditional caveat emptor approach in an effort to protect buyers. The prevailing rule in California requires the seller to disclose any material facts, by which we mean facts that significantly affect market value, if those facts are unknown and inaccessible to the buyer. But as you see from the Reed opinion, this rule inevitably boils down to a somewhat amorphous good faith test. See paragraphs 10 and 11, where the court quite correctly calls materiality, quote, a label attached to a normative conclusion. The innovation in Reed is that the court extends this rule to non-physical defects. In this case, it's the stigma associated with the decade-old murders. But notice that the court insists that the plaintiff must prove a quantifiable effect on market value. Now, what about the spookiness in Stambovsky? Let's start with the background legal rule for nondisclosure in New York. The big problem for the buyer is that New York adheres to caveat emptor, as you can see in paragraph 6. Exceptions exist for a confidential or fiduciary relationship, and for active concealment, that's fraud. But neither exception even remotely applies to these facts. So how in the world does a Stambovsky decision find grounds for rescission? The court ostensibly imposes a duty to disclose a latent defect. But such a duty directly contradicts the prevailing rule of caveat emptor, so getting to that result requires some fancy footwork. The court begins in paragraph 7 by invoking principles of equity. Then in paragraph 11, the opinion suggests that the contract's as-is clause should be limited to physical defects. Evidently, the presence of poltergeists isn't embraced within the clause's, quote, any other matter or things affecting or relating to the aforesaid premises. The court also invokes the Cohen case, which involved a seller who only partially disclosed the street's plan for the property being sold. This partial disclosure tended to conceal the facts and thus was a basis for rescission. But notice that the Stambovsky opinion in paragraphs 10 and 13 refers to the fact that, quote, the seller deliberately fostered public belief that her home was possessed. Careful reading suggests that the court's holding is narrowly limited to situations in which the seller created the condition, in this case by publicizing the haunting in the local and national press. The situation is vaguely analogous to partial disclosure because the seller tells the public about the haunting but doesn't tell the prospective buyer. Are you completely happy with these rules from Reed and Stambovsky? We can surely empathize with a buyer who later discovers something unpleasant about the home she's just purchased. But do you have any doubts or concerns about how these rules might affect real estate sales? Please pause the video now to think about this question and jot down a sentence or two describing any problems you foresee. expanding the grounds for rescission undermines the finality of real estate sales. These rules encourage buyers who've had second thoughts to sue for rescission, alleging somewhat amorphous injuries. Sellers also face a dilemma in deciding what exactly to disclose. It's easy to see how legal policymakers might be reluctant to create new grounds for rescinding real estate sales. As it turns out, legislatures in a number of jurisdictions have responded to rulings like these with so-called stigmatized property statutes. These laws expressly provide that there's no duty to disclose non-physical defects. They thus reject the principles of Stambovsky and Reed. In addition, many legislatures have established rules requiring the seller to prepare a disclosure statement for specific physical defects. But the statutes generally eliminate any duty to disclose anything else. In more conservative jurisdictions, the statutes enumerate a comparatively narrow list of specific defects. More liberal jurisdictions, such as California, tend to have broader and less clearly defined disclosure duties, for example, anything material. Thanks for listening.